The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We are here this morning for 4 different cases to be submitted to the court. The case of Joseph Goshi versus WMG is hereby submitted without oral argument. And the case of State of Iowa versus Timothy Basquin is also submitted at this time without oral argument. The first case set for oral argument today, excuse me, is Riley Drive Entertainment et al. Versus Governor Reynolds et al. We will begin with, I believe it's Mr. Mallory who's going to start.
Honorable Chief Justice, is it permissible to remove my mask while I'm at the podium?
Yes, it is. Thank you.
Thank you, Your Honor. May it please the court. Counsel. This is not simply a case about bar closures or about bars. This is a case about when can the governor of the state of Iowa unilaterally, based upon a declaration that the governor makes, take over legislative functions, suspend legislative enactments. At its heart, this is a case about separation of powers. Clearly, COVID-19 has posed significant challenges on Iowa and its government. And we acknowledge that our state government has an important role in minimizing the effects of COVID-19. However, challenging times do not simply mean that we disregard our constitutional rights. Challenging times do not allow the governor to violate legislative enactments. This court has an obligation to determine whether or not the actions of the governor related to the proclamation is in fact constitutional and whether it satisfies the statutory directives of the Iowa Code. Now, in Iowa, we have a 2-tiered system when dealing with police powers and health situations. We have the general police powers and we have the emergency powers. Some have thought or indicated that it's necessary for the governor to make these declarations in order to take actions against or to fight COVID-19. That's not the case. Iowa Code Chapter 139A, that's where we find our communicable and infectious diseases actions, which grant specific powers to our executive branch and the Department of Public Health. Iowa Code 135 specifies the duties of the department related to health issues in the state of Iowa. We have local boards of health, Iowa Code Chapter 137. It is not necessary for the governor to declare a public health disaster in order to act. Now, the state argues that the governor has legal authority to declare an emergency. We agree. Iowa's legislature has saw fit to enact a statute that allows the governor to take over these emergency powers in very limited instances. If we look at 29C1, the statement of policy related to the emergency powers, it is only the powers conferred within 29C which are granted to the governor. They are not broad and they are not unlimited to do what she wants. Now, 29C requires, this is subsection 6.1, requires that the proclamation have a couple of things. One, it must be in writing, indicate the area affected, and the facts upon which it is based. Now,
isn't it over? I mean, what is this court supposed to do now? This ended in September of 2020.
I think Your Honor is referring to mootness, and no, this case is not moot. And in fact, the facts of this case establish why this court must rule and why the case is not moot. Your Honor.
Excuse me. It is moot, isn't it? I mean, the bars are open. The order is no longer in effect. The issue is there an exception to mootness that might warrant our hearing the case, isn't it?
They submit that this case is not moot, Your Honor, and the proclamation itself, the restrictions went beyond. When the bars reopened, there were still restrictions in place. If we look at current
Place now.
restrictions, proclamations are still in effect. The restrictions are not on the bars. But the fact that the governor has backed up on her illegal actions does not render those illegal actions valid.
She entered other orders, and it did not go back to the level that you are complaining of now.
The thing about this that is so important for this court to recognize, this is not a case about COVID.
Question?
Could you repeat the question, Your Honor?
Subsequently enter another order that was not as restrictive as the one you are complaining of.
Yes, there are 48 proclamations, I believe, that have been issued. And that's why
That it hasn't gone back, that it's not as, that the level of severity is not the same. You're not affected the same way.
no, our civil rights have been violated. This court has an obligation to determine whether or not the proclamation was entered in accordance with law. This court has an obligation to determine whether or not the governor has the authority to do what she did. What this court is deciding is precedential on every future act of the governor related to emergency proclamations.
Excuse me. And let me state a concern I have in this case. Emergency powers is a very delicate area. And as my colleagues know, I am not a fan of the political question doctrine, and I've resisted ducking issues. But here, we've got a very delicate framework. And I'm kind of reluctant to go dashing off and said, you know, yeah, you've asked for a resolution of 9 questions in your brief, or maybe, and I am reluctant to cast in stone some law that we may not have a fully developed record on, and what does the next emergency look like? We don't really know. Is it really that helpful for us to try and dive into this area of law? Shouldn't we just stay available and await developments?
I agree with Your Honor that the record has not been developed because this was decided on a motion to dismiss. We should have a right to develop the record, and that is the reason why this case should be reversed and remanded. More importantly, we are not asking this court to substitute its judgment for the legislature.
What you asked for, and we said, this is a motion to dismiss, more facts need to be developed, we'll reverse and remand. What help is that decision to anybody?
First and foremost, it's going to give guidance to this governor and future governors as to when
The decision based on pleading standards, and that, you know, there was a potential cause of action somewhere, somehow in your petition. That's not really guidance, is it?
At the heart of this dispute is whether or not the governor has to satisfy the requirements of the statute. The petition asserts compellingly that the statute was not complied with, and the statute specifically states what is necessary. And the reason...
Part of your case that may not be moot? I mean, obviously you sued to get reopened, and you were reopened promptly. But what about the lost revenue during that time? Did you plead a claim for money damages?
I forgot. Justice Oxley, can you hear us?
Good morning, Chief. I can.
Oh, I'm so sorry. I meant to do a sound check. Justice Oxley is participating remotely. Okay, so if you want Justice Waterman to re-ask his question, he will. Sorry for that interruption.
The question relates to...
Plead a claim for money damages, and if so, is that moot, or is that something that should be, is yet to be answered?
Is yet to be answered. It was dismissed, and it should be. This case should be reversed and remanded. This case needs to be determined on the merits. The record needs to be developed. The fact.
Money damage claim. How do you get around the state Tort Claim Act requirement that you go to the appeal board first?
The court wrote that in the opinion. I was a little confused. At no point in time did anybody ever allege, until oral argument, that that body of legislation was even applicable. And on a motion to dismiss, you assume the facts are true in the petition. And so then, and if those facts are true and we have a valid cause of action, an affirmative defense would be that we have failed to exhaust administrative remedies. That was never asserted before the lower court in any pleading. At oral argument, that issue was brought to the attention of the court. And frankly, the reason that I don't believe that it is even applicable is not only was it not raised as an affirmative defense, the facts were not developed. That considers matters outside of the pleadings. We don't even know if that tort claim, there are a number of exceptions to the Iowa Tort Claims Act. And
To be remanded, what facts do you hope or believe would be developed that would prove the claim?
first and foremost, the statute requires, the legislature requires that the facts supporting the proclamation, that they be in the document itself. And we believe that the facts will establish that the proclamation is invalid on its face. But beyond that,
I mean, we can read the proclamation and see if it states facts. So what evidentiary facts do you hope to develop on remand that would prove a violation of the statute? Specifically, I assume you're talking about 135, 140? Okay, so what facts do you hope to develop that would prove that these things are not true? I guess you'd be proving a negative?
if they were even made, if the allegations were even made by the governor, that would be one thing. But the governor doesn't even make the allegations of high probability of anything in the proclamation. And so when we look at the statutory scheme of high probability of any of the following criteria, including widespread exposure that poses a significant risk of significant future harm, these are things that aren't even alleged in the proclamation. So those facts, the proclamation on its face is invalid. But more importantly, we would expect and do expect that the information and the facts developed will show that there's nothing about this proclamation that was either reasonable or necessary to control transmission of COVID in these counties.
It would be then, let's take 135, 140, B1. Your argument is that as a matter of law, the governor could not reasonably believe that COVID might cause a large number of deaths in the state of Iowa.
The statute requires, Your Honor. It requires a high probability of a large number of deaths in the affected population. And therein lies the issue. We have novel viruses all the time, and they don't cause large numbers, high probabilities of large numbers of death or illness. If we look at COVID-19, 718,701 positive tests in the state of Iowa, 8,201 deaths. Every death is important. Every person is important. We're not saying that those are, that we like that has happened, but it is a fact. But that is 1.1.
And I want to have you give an argument for an exception to the mootness. I'm still having a hard time getting around that.
That's 1.14%. So under no standard.
Legal standard for measuring a large number of deaths or widespread exposure, you tell me the percentage threshold that as a matter of law, the governor's proclamation becomes unreasonable.
Large number of deaths, that's got some wiggle room. High probability does not. You cannot,
Claim. You tell me the threshold at which a court can say that determination was erroneous as a matter of law. Is it 2%, 8% death rate, 10%?
means more than 50% of the large number of deaths in the affected population. Once you go to the affected population, then you're looking, frankly, in excess of 50 cents or 50%.
There's some authority to back that up.
Common law definitions of probability, more likely than not. And when we look at high probability, 1% is not a high probability of anything occurring.
Understand this. You said 50%. Yes. So it's your belief that unless the governor believed that 50% of the people in the affected area would die from COVID, she had no legal authority to take any action. 50%.
She has legal authority. Well, the question is whether or not she can usurp our constitutional separation of powers. There's a reason why this power is very limited.
That it was 49% were going to die, but not 50. And she stipulated that, then you'd win this case?
49% are going to die, but what's the probability of that occurring? And that's where it is that the interplay, we can't just look at the numbers. We have to look at the probabilities of something happening within the affected population. And therein lies the debate. But the fact of the matter is that under no set of facts do we see anything close to a high probability of anything occurring. And in fact, the governor's own actions and own numbers indicate that the vast majority of individuals who are affected have little or no problems.
Question I had, because it really is an elevator speech now, because you're about 30 seconds over. What's your best argument for an exception to the mootness? I know you don't think it's moot, but let's assume for argument's sake it's moot. What's your argument?
Ongoing. We've had 48 proclamations. We need future guidance. If we do not issue a ruling in this case, what the court would be sanctioning is governor can make an illegal proclamation, enforce it for 30 days, and back up on that illegal action, and it is absolutely incapable of review.
You got to court on this, and you got to court on this quickly. Why couldn't that happen again?
If this ruling stands and that you do not have the ability to develop the facts on the merits, and if the voluntary cessation doctrine is adopted to the point where you say, well, if she voluntarily stops the illegal action, we won't take a look at that, then it is absolutely impossible for this court to review an action of the governor when she takes an illegal action and then 30 days later changes that illegal course. That is why it's so important for this court to act at this time on this case. This is not a COVID statute. This applies to all.
A chance now. You get another crack at it in a moment.
May it please the court, counsel. Good morning. My name is Tessa Register, and I'm here today on behalf of Governor Reynolds and the Iowa Department of Public Health. I'd like to start with Justice Waterman's question about damages. In the amended petition, there was an added Godfrey claim for those constitutional violations. Subject matter jurisdiction can be raised at any time, no matter what. It was raised that they did not exhaust their remedies. That was an open question. This was argued right before Wagner came out. We'd argued Wagner, it hadn't come out. Wagner came out in December. So the district court predicted that this court would find that exhausting administrative remedies with the state appeal board was required. You held that in Wagner. And so that's also nowhere in the appellant brief. So as a matter of appellate procedure, that issue has been waived on appeal. Let's talk numbers. So on page 35, plaintiff agrees that the court can take judicial notice of transmission rates and death rates. And as of August 27th, there was 1,082 deaths in Iowa. And I think the context of that number has been a little bit lost. That is not what COVID did in a vacuum. That is not what COVID did naturally. That is the product of substantial public health efforts and personal sacrifices. We took kids out of school. We took adults out of offices. People got married over Zoom. People met their grandkids through a window. And we didn't do that for nothing. We kept people out of jury boxes. And we did that to save lives. And I'd like to think that wasn't for nothing. And we did save a lot of lives.
Let me ask you about one aspect that they've raised. This particular order only closed bars in 6 counties. So it seems, one could argue it was the governor's determination that a bar in Polk County was a danger to public health, but a bar in Warren County was not. Isn't that sort of a discrete equal protection issue that we can review, even if it is moot?
I'll do the mootness first, then I'll go to merits on choosing counties. So as far as mootness, I mean, I think our merits are strong, and I think it survives equal protection review. And so the reason we raised mootness is because I just think we have a big recurrence problem, right? And so when we looked at mootness cases and public importance exception cases, something that was emphasized consistently by this court was the recurrence of it all. And so, you know, for the Supreme Court in the Roman Catholic Diocese case, right, Governor Cuomo was constantly changing those color codes, right? And so, yes, they went from orange to yellow, but the reality was that was happening every couple of days. And so it wasn't moot. The scheme was still in place. And then looking at your recent case in Lacey for the partial convictions, right, one count but not the other, you emphasize that that was happening all the time. They were going to trials all the time. And then also in Avalos Valdez, you emphasize the immigrant population in this state, right, to emphasize that this is going to happen again. And so, yeah.
I agree COVID is ever changing, but this idea of sort of selecting particular counties out and targeting those counties but not others instead of making a statewide order, that seems like a discrete issue that could well recur. So why shouldn't we opine on that?
It's fairly well settled that the governor doesn't have to tackle everything at once. She can choose problems. She can choose.
Say hypothetically, I'm not saying that these are the facts, but let's say hypothetically they were allowed to take discovery and could develop that those particular five of those 6 counties are counties that politically are controlled by the opposing political party. Let's say they developed evidence that there was a political motivation. Would that be a case that they should be able to try?
Traditional rational basis review. You have to negate every possible classification. And so they could say this was political, but I think we can say, 1, no, it's not. And 2, there were compelling reasons to choose these counties, and these plaintiffs are Polk and Dallas, and I'll explain why. So Polk is the largest population in the state with around 450,000 people. Dallas in 2020 had about 99,000 people. And if you look at that map, there's a Unity Point campus, a Mercy campus, an Iowa Clinic campus right on the border of Polk and Dallas. There are key medical systems right on that border. And community spread, regardless of the cause, can have a domino effect in large populations. I think the governor could rightly conclude that when we have higher population density, community spread poses a risk to everyone in that area. And so when we're looking at a pandemic response, right, a workforce that we cannot lose, the workforce cannot go, is the healthcare workforce. So I think...
I get all that, but let me go back to the question of motion to dismiss. The question is, well, I mean, are they entitled to some discovery to show, I mean, political motivation maybe, or to show that the facts aren't what you claim they are? Are they entitled to at least develop it a little bit through the discovery process, which a motion to dismiss, of course, doesn't permit?
For rational basis review on a motion to dismiss, they have to negate every possible offer justification. I don't have to put on evidence at all.
Has some discovery so they can negate. I mean, maybe, supposing they did discovery and they found, I mean, who knows, they found documentation to suggest that the rational basis that you're suggesting was not valid. Just wasn't so. Don't they have an opportunity to try and develop? I understand you're saying they have to negate everything. That makes me think they really need discovery if they have to negate everything.
Contrary with how this court has reviewed rational basis in the past. I think the King case, I think the Sanchez case, it has to be conceivable, right? It doesn't have to actually play out. It just has to be conceivable. She just could have reasonably believed.
Why not include bars in Davenport, in Scott County, part of the Quad Cities, over 300,000 in population, some major hospital systems there?
We didn't see that population come up. That wasn't a population she was worried about. It didn't have the density that Polk and Dallas have together, right? Particularly that healthcare system right on the border. And so based on the numbers and the trends she was seeing, also, I mean, she has to weigh so many things. She has to weigh economic impact as well. I think she could have closed bars in all counties, and I'd be here defending it too, and that's fine. But she doesn't have to do everything or nothing. I think she can choose what can our economy withstand.
The historical background of Article 1, Section 6, the Iowa Constitution, what we call our Equal Protection Clause, It seems like our framers were very concerned about geographic discrimination, picking on one county as opposed to another. And I mean, that's what happened here. So why shouldn't there at least be an opportunity for discovery?
What facts could they do to negate the fact that those are highly populous areas, that there is major healthcare systems in that area, and that COVID-19 spreads person to person, and in denser areas, the risk of domino transmission is reasonable. I don't think they're going to adduce facts to show that that was an unreasonable conclusion.
To dismiss, so they weren't allowed that opportunity. And yet, it looks to me, and you can correct me if I'm wrong, didn't Dr. Padati make statements at the temporary injunction, and that was not part of the initial document, the initial petition?
Mischaracterized. So there was a TRO proceeding where they submitted, I think, 55 exhibits as well, and one of our exhibits was an affidavit from Dr. Padati. That's fair game for a TRO proceeding. It was not used by the district court at the motion to dismiss stage to make any factual finding. It's only discussed in the context of equal protection, where the court can just itself conceive of a rational basis, right? And so that the court had an easier time coming up with a rational basis because of the case law we found, because he had already heard Dr. Padati's affidavit earlier, a month and a half ago. I don't think that is a factual finding. If the court can conceive itself of any basis, that survives rational basis. And so I don't think he was...
Counsel, so going forward, what is a petition alleging equal protection that would be subject to rational basis going to look like? So plaintiffs are going to have to not put any facts in their petition just to avoid a motion to dismiss. Why should we not be concerned that if we rule the way you're asking us to rule, then equal protection all of a sudden becomes a motion to dismiss and it never gets beyond that stage?
I think it entirely depends on the level of scrutiny. I think here rational basis is a special...
Okay, so we're assuming, right, so we're assuming rational basis. So if you have an equal protection claim that you admit is subject to rational basis, does that mean that the plaintiff needs to not put in any facts so that you can't get dismissed on a motion to dismiss and then get to discovery? Tell me what that petition is going to look like so that they could get past the motion to dismiss basis.
I think it's incumbent, and it can be through argument at the motion to dismiss stage or in the petition. They're going to have to undermine every conceivable basis. So I'm thinking of the Sanchez case. I'll use that as an example. I mean, they'd have to put in that petition enough facts to undermine all of the bases to exclude undocumented individuals from our state driver's license program.
Decided before the second Racy case. And in the second Racy case, didn't we say that we've adopted an approach to equal protection under the state constitution that has more teeth? In fact, we threw out in that case a differential tax rate where racetracks were being taxed at a higher rate than riverboats. And that was also kind of a geographic discrimination as well.
Surely this court has recognized it has rational basis with bite, right? But I don't think this court has ever recognized geographical location as a suspect class. I think it's still rational basis, and they're still going to have to negate every conceivable basis. And so they're welcome to say this was political, but they have to they still have to undermine all of the non-political justifications for this classification, and that they can't do. In a pandemic, the governor gets to protect healthcare workers, and particularly in community spread at this time as well. If you remember, we were just bringing kids back to elementary, middle, and high school, right? And that back to return plan was based on percentages, right? County.
Example, in that instance with the schools, the governor's lawyers have been in court arguing there needs to be a uniform statewide policy on schools. And yet here with bars, it was 6 counties, right?
There was a uniform rule in that it was based on the percentage, the positive case percentage in each area. So there was a uniform rule. It just wasn't that some counties were going to go back because higher and because they weren't as high, and some counties were going to go, or districts were going to go because they were under that 15% threshold. So I think there was a uniform rule, and then the transmission rates dictated whether they were back or not.
This issue, the governor can't get around it simply by stopping, right? Because she can start again. So what's your response to that? How do we stop the governor if, in fact, this was wrong?
That, first, it was not illegal conduct at all. But second, I think the governor should be encouraged from making data-driven decisions and not litigation-driven decisions. And she'd made the decision once, if you look at the map, at the case counts, it leveled off, right? It climbed sharply and it leveled off. And once it leveled off for a certain amount of time, she lifted it early. And I think that's a data-driven decision and that should be encouraged. I don't want our government making decisions, well, I don't want it to look bad, so I'm just gonna keep it going longer. And so I think that's I don't know that there's any inference that she was making decisions motivated by litigation in this case. And as far as, I think, could she institute it again? Could she? Sure, but I think that's not the standard. The standard is likelihood of recurrence. And I think, run out of time here, but they cite a case called the Green case that I actually think is really instructive. And so in that Green case, it's the Waterloo School District. And in that case, they wanted to target teenage marriage, and so they prohibited married high schoolers from doing extracurriculars. This basketball player gets married, he's a senior, gets kicked off the team. The rule's still in place, and while he's litigating, the kid graduates. The rule's still in place, and so they reach the issue and they say, this is really important, we gotta do it. But if in that case, the kid had not graduated, they had rescinded the policy, he was back on the team, and Waterloo had instituted a new approach to targeting teenage marriage, I think that case comes out different. And I think that's what we're looking at here. We see the governor rescinded it once cases leveled out, and then in the future when cases got bad again, she tried a new approach, and substantially vaccines have really changed the game. We now have a vaccine. In August of 2020, what was particularly dangerous was this was ripping through an unimmunized population, and we don't have that now. We have excellent vaccines that allow people, it's not ripping through an unimmunized population the way it was in August, which speaks to the compelling nature of it. And so I don't think, this falls within the voluntary secession to the extent that it's distinct from public importance exception.
We're talking about a kid not being able to play basketball because of married. That seems archaic now, but that is easy to imagine that was likely to be repeated. Yeah, high schoolers are always up to shenanigans. But in this situation, although a pandemic, I would like to hope that none of us will ever experience another pandemic in our lifetime. But for that very reason, when we were scrambling like crazy about 2 years ago, man, some guidance would have been nice. We had nothing to lean on. We were starting from scratch. So the mootness issue, perhaps maybe because it's so huge, this is something that we should talk about today for the people who take our place down the road. What do you have to say about that?
So is COVID-19 important? Of course, no question. But I think it's not that broad. We have to look at what you're actually being asked here. And the precise questions are, in August 27th, 2020, was there a disaster emergency? On August 27th, did this particular language meet the statutory requirements?
So there's also just the authority of the governor. So let's just focus on more of the general aspects. Wouldn't it be helpful and behoove us to perhaps give some guidance to future citizens of Iowa and our court members?
Sure, and I think, to be clear, I think the governor's conduct meets the statute, and so something we talked about when raising mootness is, do we just take the win, right? Do we just get the authority and say, yes, we did this correctly, let's seek a ruling? But I don't think parties should get to say, moot if we lose, not moot if we win, right? And so I think it doesn't meet the exception to mootness. But I think it matters who's asking, right? And so the way I've been thinking about it was the foundation of this is the governor's ability to declare an emergency, right? That's what triggers everything else. Once she declares an emergency, local health plans can start to be activated, state disaster plans can be activated, this court can take responsive action, administrative rules trigger, right? So we have all these things, this is the foundation. And I think it matters who's asking you to shake that foundation. And if someone's gonna ask you to shake that foundation, I think they should have something to gain or something to lose if it falls. And so I think there's a good standing analogy there. Standing and mootness are siblings, not twins, right? But I think there's an analogy there, and that it matters who's asking. If they're going to do something that big, I think they should have something to gain. For those reasons, we ask that you affirm. Thanks.
Thank you, Your Honor. Reoccurrence. We've had pandemics for thousands of years. H1N1, HIV, COVID, smallpox, typhoid, cholera. It is going to happen again. It's not a question of if, it's when. But more importantly, the statute doesn't apply to pandemics alone. It applies to all emergencies. And why have we set that bar so high here in the state of Iowa? As Justice Appel said last year in his dissent in State v. Warren. The founders of both the United States Constitution and the Iowa Constitution had a very skeptical view of state power. When it came to state power, they were cynics. They believed that government needed to be restrained by enshrining the Iowa Bill of Rights in the first substantive article of the Iowa Constitution and through the separation of powers amongst three branches of government. And in this case, we are all concentrating on this one closure issue. But when an emergency public health disaster is declared, look at what the powers do for the governor. They can have suspended regulations and statutes. They can control travel in the state. They control the movement of people. They can have forced physical examinations of individuals, forced vaccinations. This is Iowa Code 135-141. And if you're not going to undergo a forced vaccination or forced medical treatment, they can force you into quarantine. Those powers alone are why the bar is so high to get to a public health disaster. It's because we are going, as the Attorney General said in that 79 opinion, the governor is granted or is exercising these sweeping powers, and we are deeply intruding upon the legislative process. And therein lies the heart of our position. It is that when you are going against the Constitution, when you are going against the norm, there should be a high bar. And in this case, they simply, the proclamation doesn't set.
Ms. Register, at the end of our argument, made a pretty good point, which is you're making for a really big ask, and in this case, and if you're going to make for such a big ask, shouldn't we at least wait for a case where it's going to make a difference?
Of any case better than this where it's going to make a difference. We're looking at a case where a governor, on its face, the proclamation doesn't satisfy any of the requirements. People's livelihoods ended. It's not just money was lost. People lost their jobs. Businesses closed. And a governor doesn't have a right to do that. In Iowa, when the times get tough, we don't throw the Constitution out the window. We don't live in an autocratic state. We don't live in a bureaucratic state. And what happens when you allow the governor to suspend regulations and procedures, you are akin to the governor acting as the legislature and the executive branch, which goes against the core principles of our state.
Difference that the legislature has not enacted anything to narrow the governor's emergency powers since COVID started?
The legislature has enacted limiting powers, and that's 29C. No, the legislature has not taken action to override what the governor did. But that is the exact reason as to why this court must act. When you have two branches of government that may be doing something wrong, this is the body that has to say no. You have to comply with the Constitution. You have to comply with the statutory scheme. This court, it's held in First Trust Joint Stock Land Bank that Iowa courts will review a finding of emergency to determine whether such in fact exists and whether it justifies the exercise of emergency powers. We are not asking this court to do anything other than enforce the Constitution, enforce the statute. That is it, nothing more. Thank you.
Drive et al. Versus Governor Reynolds et al. Is hereby submitted to the court. We'll take just a couple minutes here to transition for the next case, which is Site A Landowners versus South Central Regional Airport, City of Pella, City of Oskaloosa, and Mahaska County.